Andrea Humphrey here with Rebel News, standing in front of the BC Supreme Court on Nelson and Smythe in Vancouver because it's day one of a very important hearing that's taking place, seeking to get certification to sue the government of British Columbia over their declaration of a COVID emergency.
Today, in addition, we have taken the extra step of declaring a public health emergency in the province of British Columbia.
All right, I just got out of day one of the hearing. It's been brought on by the Canadian Society for the Advancement of Science in Public Policy. From the SueBonnie.ca campaign, a campaign run by the Society and fueled by supporters who are seeking accountability from the province's public health officer, Dr. Bonnie Henry, for the harms that the COVID-19 restrictions she implemented in the name of an emergency caused some British Columbians. Such restrictions include limits to mobility within BC, limited right to assembly, delayed and cancelled surgeries and other medical procedures, and of course, vaccine mandates that affected businesses and people's ability to work.
So a new provincial health officer order will require individuals to provide proof of vaccination, our BC vaccination card, to access certain social, recreational, and discretionary events and businesses throughout the province. As of September 13th, you will need to have at least one dose of vaccine to enter these settings. And by October 24th, entry to these settings will require people aged 12 and older to be fully vaccinated at least 7 days after receiving both doses.
What is happening here, what just ended for day one at least, is that they are trying to seek certification to have a class action suit. Now, they have had many supporters. In fact, the room was the largest, at least one of the largest rooms in there, and it was packed. I had never seen people sitting on the floor in a courtroom before, but that's what actually took place. And in the front 2 rows was a lot of healthcare workers. Some were in their scrubs and some were not. So it's very clear that this is a matter of public interest. The justice residing over the matter is named Justice Criar. He comes across as a very reasonable judge. In fact, he did something I haven't seen routinely done in many of the COVID-related cases I've covered out of BC. The first half an hour or so of the hearing, he actually broke down what type of hearing this is and really clearly explained it, as well as the parameters for which he can rule on. Is this case going to be appropriate for a class action or not? He did that for the gallery. And a little bit of history of this, the society who's bringing on this case actually did something unprecedented. They sought to have their hearing broadcasted, and the judge himself said, this is experimental. He granted them the ability to do that. It's something that hasn't been done. And there's a little bit of back and forth about where the hearing will be broadcasted. The society wants it on YouTube so that it's easily accessible. And the judge's order, who went ahead and said, okay, I agree, this is public interest, he put parameters on where it could be broadcasted, which included that it shouldn't be monetized. So what happened was Dr. Henry, the government's lawyers, were in there today. They tried to really fight that from happening in the first place. And today they showed up, even after the order's there, and said, oh, you know what? If we air it on YouTube, it doesn't align with YouTube's terms and conditions. So there was a little back and forth. They're going to reconvene about that issue in the morning. But the justice did caution both sides. He said, I went to bat basically to have that order in place for a reason. So please be reasonable with what you come up with. One more thing on this, because I think it's so interesting. He suggested a third party, and there was a little bit of back and forth about that. But he also suggested, hey, I know, why doesn't this just go on the provincial government site? And the government's lawyers said, no, we don't want that. We don't want to look like we are promoting this case. We will update you on Rebel News what happens. And I also have an interview with a Mr. Kip Warner in this report that you're watching right now. He is the director of the society. So he's going to break down some of the questions I still have about this. But yeah, it was a big turnout, and let's get to Kip right now. All right, Kip, it's the evening after a full day in court. Thanks for being on Rebel News.
Thank you for having me.
Now, I already briefed the people watching a little bit about what happened in court today, but I guess a question I have for you, because I think this type of case when it comes to COVID type fights is different. You're pursuing a class action. So my question to start is, why a class action versus, let's say, a judicial review like we've been seeing a lot of?
Yeah, it's a good question. So judicial review seems to be the standard approach that a lot of other legal challenges have taken. And unfortunately, people have found that the Judicial Review Procedures Act is it's pretty limited, as we're finding it doesn't have the teeth that people thought it did. And unfortunately, you don't have a real discovery process in judicial review. You can potentially cross-examine on affidavits, but it's very limited. Whereas with a normal civil suit or a class proceeding, if or when you get to discovery, you have a real discovery process to discover the strengths and weaknesses of your opposing parties' evidence. They have to produce witnesses when compelled to do so, answer questions, and that's not something that comes easily in judicial review.
Now, the justice, he did this long explanation explaining what the hearing is. I thought that was interesting and pretty neat. And he also explained the sort of guidelines he has to follow in order to make a decision in this. Are you or the society, are you guys at all concerned about being the sole plaintiffs in this case, as far as if that's going to help you get this class action?
Well, we'll have other individual plaintiffs as well. It's mainly a perfunctory or clerical thing. But the main plaintiff is and always has been CSASPP as the representative plaintiff. We started the proceeding, we've been managing it, we fundraised it, we've been instructing counsel, we've been dealing with all the issues and procedural obstacles along the way over this 2-year journey.
Yeah, it's been a while. It's been an ongoing fight. Now, let's explain for people watching, if you go ahead and get this certification, what exactly does that mean to British Columbians and Canadians? And just to clarify, what does that mean for Dr. Bonnie Henry? I know many people think she's going to be sitting on the stand or something like this, and this at the moment isn't a trial. So maybe if you can touch on a few of those things.
Sure. So the second part of your question regarding Bonnie, she's not going to be on the stand at this week's hearing. This is the certification hearing. I wasn't surprised to see the courtroom packed, and I don't think you were either. But I was very happy to see that our judge is very patient. He takes this opportunity to take a pedagogical approach, teaching people. He knows that this courtroom is not filled with lawyers. It's rank and file British Columbians who come from all walks of life, and he's explaining what it is that he's doing today and not doing today, and how class proceedings are different from normal suits, and the type of decisions that he has to make in this step, and why Bonnie's not there. So the certification hearing, which is what we were hearing today, that is necessary only in class action. So normally when a few people sue a few people, they don't need a certification hearing. But if they bring a suit as a class action under a statute, a provincial statute called the Class Proceedings Act, they need to go through a process called certification. And that is a step where a judge looks at the case, at the form, rather than the substance of it, and determines, is this suitably framed to be heard as a class action? As in, are the categories of people that are allegedly affected by whatever it is you're claiming bad behavior the defendant did, do they fit into categories that are well-defined, one or more classes or subclasses? Is there a common issue to be tried, and so on? It's technical, but it's essential. And without achieving certification, you don't get access to the discovery process. So in a normal suit, normal civil suit, the plaintiff files their pleading, the defendant files their response, and then they exchange documents, they interview each other through what's called an examination for discovery, and that process often ends with a settlement, or the defendant might bring an application to throw it out, seeing that the other side doesn't have a case. There's any number of things that can happen, but the point is that they have access to those discovery tools. Whereas with a class action, it's kind of like a nuclear warhead. It's a very powerful tool, but it's not an agile weapon. defendant. So you have to overcome the certification process, at which point you then have discovery. So in class actions, the discovery or certification is actually the most important step in proceeding, arguably more so than a trial. In fact, most class actions never see a trial once they've been certified. They settle simply because it becomes too costly and burdensome for a defendant to deal with instead of just one plaintiff and potentially 5 million plaintiffs.
Now, Ms. Furtula, your counsel, she argued or did some of her submissions today. I imagine tomorrow on the 13th, she'll be doing more. She touched on quite a few things. She started off with, because this is about the actual claimed emergency. So she started off with mentioning things like the PCR test. Something I found interesting was when she talked about how certain COVID deaths weren't necessarily COVID deaths, how there was so much testing. And, if you had cancer and you died, but you had COVID, that could be a COVID death. And the justice seemed very surprised to hear that. He said, interesting. So, of course, that was interesting to see. We'll be watching this closely and informing people on what happens next. I know that the justice did mention that around 60 to 66% do get certified. So we'll see what happens here, and people can find out more information at suebonnie.ca. Thanks for being on Rebel News.
Thank you.
Well, that wraps off day one of this hearing. As I mentioned, the Society's lawyer, Ms. Furtula, did part of her submission. She's going to continue tomorrow. Today is December 12th as I'm filming this. You'll probably see this a little bit after. But once again, I've got to point out, just like all the other cases that I have covered that are very important, they're in Supreme Court. There is no legacy media in sight. But thank God I work for Rebel News, where we bring you the other side of the story. And if you appreciate that we do that for you, please consider helping us keep the lights on, helping us be able to come out here, have our boots on the ground, and bring you these reports. And an easy way to do so is just to give a donation to help support us at rebelnews.com/donate. Drea Humphrey for Rebel News. Well, more truth is being unfolded, whether the government likes it or not. And if you like that Rebel News is here to inform you about it, consider supporting our journalism by donating at rebelnews.com/donate.